thank you very much. And thank you for inviting us and including us in this very important conference. First of all, the paper that we are presenting today is based on a legal brief that we wrote this summer with our colleague, Professor Koen Veter, Professor of International Law at the University of Antwerp. We co-authored this brief in the wake of the ICJ advisory opinion of 19th of July, 2024 on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. Unfortunately, Koen passed away very suddenly 2.5 weeks after we finished the legal brief on 20th of September. Koen was the leading force behind the institutional collaboration between the Mouwatin Institute at Birzeit University and the Law and Development Research Group at the University of Antwerp, to which Thalia and I belong. We all remember him as an exceptional human being and scholar, and his absence leaves a lasting void in all of our communities. Today, we are trying to do justice to his scholarship and present his parts also of our common work as accurately and as respectfully as possible. In our presentation today, I will first address the peremptory norms of international law that Israel is found to be violating. We will then turn to the responsibilities of other states with respect to these peremptory norms. Then we'll look at the place and the responsibilities of universities and address that. And in the next part, my colleague, Thalia Kruger, will address how universities can go about their existing research agreements. So I'll start by pointing out that the so-called peremptory norms of international law, or jus cogens in Latin, are recognized as by the international community as norms from which there is no derogation possible. These are so fundamental that they bind all states. In fact, I would say all actors of society, without even contractual or treaty obligations, and without objections or without exceptions. These norms include the prohibition of genocide, the prohibition of crimes against humanity, the prohibition of racial discrimination and apartheid, as well as the right to self-determination and the respect for the basic rules of international humanitarian law. The peremptory norms of international law, they give rise to obligations that are owed to the entire international community, so-called erga omnes obligations. There can be no exceptions, so neither consent, arguments of self-defense, countermeasures in respect of an internationally wrongful act, force majeure, distress, or necessity can be invoked to breach these norms. Against this background, I would like to briefly outline the relevant peremptory norms of international law that are invoked in respect of the unlawful prolonged occupation of Palestinian territories and the ongoing war in Gaza. I will not go into the details of the international processes, as these were already expertly detailed by Professor Gamze and Ziberi yesterday evening in the context of this conference. But some of these bear, I think, repeating. So the International Court of Justice found on the 26th of January of this year that Palestinians in Gaza were a significant part of the protected group of Palestinians whose intentional destruction would have an impact on the group as a whole. Therefore, the right of Palestinians in Gaza to be protected from acts of genocide and related prohibited acts falling under the Genocide Convention was plausible. And due to the urgency and in order to prevent irreparable prejudice, the court ordered provisional measures, that Israel had to take all possible measures to prevent genocide, to enable the provision of basic services and humanitarian aid. And these provisional measures over time at South Africa's request became more stringent. The ICJ ordered then Israel to ensure immediate access to food supplies and to halt its military offensive in Rafah, as well as any other action which may result in the physical destruction in part or in whole of Palestinians in Gaza. These court orders really do indicate that there is an exacerbating risk of genocide against the Palestinian population of Gaza, and this is what the ICJ opined. These, of course, obligations are of erga omnes character. They bind all members of the international community. This also means that the compliance with provisional measures and the obligations under the Genocide Convention are not only a matter of concern for the respondent state Israel in this case, but also for all parties to the Genocide Convention and all parties to the international community. And given that the ICJ has ordered progressively more stringent and more comprehensive provisional measures, citing urgency and imminent risk of irreparable harm, the measures taken by third states to induce compliance with the Genocide Convention and with the provisional measures of the ICJ can become lawfully more stringent and comprehensive over time. And in a separate legal procedure, the one that I outlined, the advisory opinion, the ICJ found that Israel's legislation and measures impose and serve to maintain a near complete separation in the West Bank and in East Jerusalem between the settler and the Palestinian communities, which amounts to a violation of the rule of the prohibition of racial segregation and apartheid. The ICJ, in the same advisory opinion, found also that Israel was violating the integrity of the occupied Palestinian territory, which is an essential element of the Palestinian people's right to self-determination. It moreover found that Israeli policies and practices in the occupied Palestinian territories were contrary to peremptory norms of international humanitarian law. And we also know that in the international criminal law domain, the prosecutor of the international
Gamze, sorry to interrupt you, but you need to slow down a little bit for the interpreter to be able to translate, please. Yes, thank you.
In the international criminal law domain, we know that the prosecutor of the International Criminal Court has applied for arrest warrants against at the time, the Hamas leadership and the prime minister and the defense minister of Israel based on allegations of criminal responsibility for war crimes and crimes against humanity. This procedure is ongoing, but has not been concluded. And all of these findings, they actually create obligations on third states to not recognize Israel's illegal presence in the occupied Palestinian territory, to also cooperate within the United Nations to end the illegal occupation, and to assist in the attainment of Palestinian people's right to self-determination. All states also have an obligation to abstain from relations or dealings with the state of Israel to recognize that illegal presence. They may not aid in recognizing that illegal presence in any manner. They must refrain from supporting materially, militarily, logistically, economically any action that would be assisting in the commission of such violation. So we see that this is a very specific situation of a large number of peremptory norms of international law that have been violated and are being violated in a prolonged manner, creating serious breaches. And it does distinguish this case from many other cases where human rights violations occur, where they are not as widespread, they are not as severe, and they are not as prolonged. And now, as a part of that obligation, of course, we dealt with the question of universities, because there are some consequences also for universities. Universities all around the world are organs of society, endowed with the responsibility to teach and to educate, and they must avoid aiding or assisting in the commission of breaches, violations of peremptory norms of international law created by Israel's illegal presence in the occupied Palestinian territory, and they have to address such aid and assistance where it occurs. The university where we are from, the University of Antwerp, is a public university. And there is also a strong argument that public universities are or may be considered organs of state under international law, insofar as the state may be held responsible for their conduct, but they are also bound by the obligations that are incumbent upon the state. This does not mean that universities do not have academic independence or that individual academics do not have academic freedom. They do, of course, but it is about an institution following international law and abiding by its most fundamental norms. And in that line, we know and have seen that Israeli universities as institutions are embedded within the exclusivist nature of the Israeli regime. And they have not also played any fundamental role in opposing the occupation. In fact, they have been also instrumental in maintaining and in some instances also expanding the occupation. Until such a time as all these violations are brought to an end, universities have a duty to act with a strict due diligence framework, departing from a precautionary principle in assessing the risk of complicity in such grave violations of peremptory norms, as well as other breaches and violations of international humanitarian law and international human rights law. And for that reason, we say that there's also an obligation to not aid or assist. And that means until such a time as these violations are brought to an end, that collaborations should not take place and those existing collaborations should cease for this time being. And regarding private universities, which is not, of course, a topic that we addressed in our brief, we also argue that they are bound by the respect for human rights as well as peremptory norms of international law, including the basic norms of humanitarian law. There is a growing recognition that private entities, such as businesses, but also private universities can be also seen in that lens, are bound to respect human rights as outlined, for instance, in the United Nations Guiding Principles on Business and Human Rights, which are also referred to as the RUGI principles. These duties are only heightened with respect to peremptory norms of international law, which create obligations for all members of the international community, which would include universities. I will now turn over to my colleague Thalia Kruger to expand more on this and the practicalities. Thank you.
Thank you. Thank you, Gamze, and thank you also. Sorry, I have an echo. Thank you also for having us on this hybrid format. Sorry. We tried, as Maha and Tommaso said yesterday evening, we really tried to get there, but we were prohibited by the authorities. So thank you for having us in this way. To continue with where Gamze left off, what should universities do and what can they do? So first of all, cooperation between European and Israeli universities can take many forms, but basically two structures. First, sort of general cooperation agreements, and second, research consortia. The first type concerns looser kind of cooperation, such as a memorandum of understanding. They express intentions to cooperate. They can be concluded at university level or at faculty level, and they mainly seek to encourage staff or student exchange. And to facilitate that kind of exchange. Sometimes they have funding from the EU, but not always. Sometimes there's no funding on those. And they have a limited commitment. They can usually be terminated upon notice. Sometimes reasons are required, and then I think Gamze has outlined enough reasons. Sometimes reasons are not even necessary for terminating these informal kind of arrangements. Many of them are at this stage, in any case, not executable due to the current context of negative advice of embassies to travel to Israeli universities, as well as Israeli students not being able to come to Europe because being reservists of the Israeli Defense Force. So this is a good time to terminate them. The second type, and this is where we placed more of our attention, are research cooperation. So Israel benefits from participating in the so-called research and innovation framework programs of the European Union. This allows Israeli institutions, universities and others, but even ministries, sometimes businesses, to be partners in research consortia that are funded by the European Union. The basis for the involvement of Israeli partners in these agreements is the association agreement between the EU member states, and Israel, dating from 1995. The association agreement is broad, and it covers various aspects in trade in goods, services, as well as technology and research. So once there's a consortium set up between different universities, and they get funding, there will be two agreements. The one is the agreement between the EU funder and all the partner universities. The second is an agreement between the partner universities. That's called the consortium agreement. So both these agreements have model forms. The general model grant agreement, that's the agreement between the EU and all the partners, provides that the project partners must commit to and ensure the respect of basic EU values, such as, and these are quoted, respect for human dignity, freedom, democracy, equality, the rule of law, and human rights, including rights of minorities. We heard a lot yesterday about hypocrisy and contradictions. In any case, aiding and assisting the violation of human rights is clearly a breach of these agreements. These agreements also explicitly state that they are subject to international law, and they're also subject to Belgian law. Belgian law is chosen because that's the place where the EU institutions are seated. And international law is considered part of Belgian law. Belgium is a monist system. There's no doubt that international law is part of that. So here as well, we are working with the master's tools, as Professor Vasanti explained also yesterday in our discussion. And the problem that we've seen with international law are also very much present, even more present, when we turn to private law, which is built on capitalist reactive approaches, as demonstrated by scholars like Katharina Pistor. Now, these agreements also contain an Annex 5, this model grant agreement, which states that no funding can be granted within or outside the EU for activities that are prohibited in all member states. No funding can be granted in an EU member state for an activity which is forbidden in that member state. This annex is considered of high importance in the interpretation of the grant agreement, as it takes precedence over the terms and conditions of the contract, the agreement itself. So in case of breaches, the funder may reduce or suspend the grant, or may terminate the grant in whole or in respect of one of the beneficiaries. If we turn now to the consortium agreement, the DESTA model, which is the model that is most used, there we don't find the same list of obligations as those in Annex 5, but this model consortium agreement states that each party undertakes to perform and fulfill all of its obligations under the grant agreement. So that means that all of these rights and duties, respect for human rights, international law, is drawn in also to the consortium agreement, so the cooperation agreement between the partners. The model grant agreement allows parties to terminate the contract, to terminate the participation of a beneficiary. The consortium agreement then sets out the procedure for decision-making and how a partner could be removed from the consortium. So what should happen is the coordinator, as the intermediary, has to discuss these issues on the General Assembly, and then the coordinator can request for a suspension or amendment to the funder, or the coordinator may request the termination of the grant agreement or the participation of one of the beneficiaries. In that last case, if it's the termination of the participation of a beneficiary, they have to give reasons, and they also have to include the opinion of the beneficiary concerned. So then the grant agreement can be amended and the tasks among the partners can be redistributed. Problem here is that they have to give reasons, and we've seen letters by the current EU Commissioner responsible for research, Iliana Ivanova, who wrote to Spanish and to Belgian universities that they will only accept termination if there are valid reasons, which keeps them in control of kicking out one of the beneficiaries. They say that these will be assessed on a case-by-case basis. This commissioner is in office until December of this year. The new commissioner will be vetted next week. So to conclude, and I conclude on behalf of Gamze and myself concerning the recommendations that we inserted in our legal brief, universities must, first of all, ensure full compliance with the obligations that states have under international law, international human rights law, and international humanitarian law, as well as their obligations under domestic law. This includes erga omnes obligations. They must therefore not recognize as legal the situation arising from the unlawful presence of Israel in the occupied Palestinian territory. They may not render aid or assistance in maintaining the situation created by Israel's illegal presence in the occupied Palestinian territory. Second, they must end all collaborations with academic and other institutions directly or indirectly impacted in the violations of international law, international human rights law, and international humanitarian law in Gaza and in the occupied Palestinian territory more generally. Third, they must put on the agenda and discuss with the other partners the research collaborations and the legal consequences of cooperating with Israeli universities. Examine the correct legal ways to terminate the participation and communicate these issues to the funder of the research project. Fourth, they must depart from a precautionary principle and not initiate any new collaborations with Israeli academic and other institutions until such time as the violations of international law by Israel are brought to an end. Fifth, by way of a single exception, they must set up a credible form of carefully negotiated inter-university cooperation that aims specifically at bringing to an end serious breaches by Israel of obligations arising under peremptory norms of international law, as recently established by the International Court of Justice. Thank you.